Now we are about to start the second session on the new family models, and I would like to introduce Professor Sharon Shacharjee from the University of Jerusalem, who will be talking about choice of law for surrogacy agreements in the in-between of stages and contracts. I look forward to your presentation. Sharon, are you there? Can you unmute? Yes. So,
okay, is it okay if I share my slides?
Floor on the... Yes, please do.
Okay, let's see how you do this.
You have a share button close to the camera and mic.
And then okay, but where do I get the slides? Sorry, just a sec.
Yes, please, just work it out. I was thrilled by your title, not only because I know what you refer to, but also because it's becoming quite cool in private international law doctrine to talk about the in-between.
Yeah. So someone who did the slides before, could they please explain? So I do share and then I get presenter mode, but then I don't get the access to my slides.
I don't know if,
yes, yes, you have the possibility to share the slides.
So I do share and then share content and then window, and but where does it get to the slides? So I thought Zoom was complicated, but okay, so this is not great. Should I send it to you, Francisco?
Yes, well, if you want, you can send the presentation, your presentation by email, and yeah, we can
it's not the best, but
do
it's
as previously with.
Yeah, okay.
So I share it and.
Yeah. Okay. I sent it to you. Okay, so while Francisco is putting on the slides for me, and thank you for that, I will just start by saying that, so hi, and thank you everybody, thank you for the invitation, and thank you to the previous presenters. That was, they gave us really interesting food for thought. I just have to warn you in advance that if there's a siren, this is in my end, there's a war going on here, unfortunately. And so if there's a siren, I have to leave. So apologies in advance, I will not have time to explain anything, so I'm explaining it now. Okay, so I will start, and once Francisco has the slides, then we will have the slides as well. Okay, so my subject, as Ilaria mentioned, was choice of law for surrogacy agreements. And basically my project is to try to give a theoretical explanation on how we should regulate surrogacy across borders. And I know this is a very hot topic. It's been a hot topic for a while now. And my proposal is a way to make an arrangement that should work internationally. So not just within the EU or within a group of nations, but internationally and in a broad spectrum. And obviously, when you want to have stability and broad outcomes, then you have to pay, or you have to give something else up. And this is the downside of my proposal. I already mentioned this in the beginning. So the first slide you should be points of contention, right? So the point of contention is when we discuss surrogacy, we have different things we're not sure about, or different points where countries disagree, right? So the first question would be surrogacy, yes or no. There are countries that say yes, there are countries who say no, and that is just it. They don't give you any other details, they just say no. Then if we say yes, we have, is it altruistic? Can it be for profit? And then we have by whom, for whom. So do you have to be a family member? Can you not be a family member? Do you have to be someone who knows the couple? You don't have to be someone who knows the couple. And then does it have to be a couple? Can it be a single person? Does it have to be a heterosexual? Could it be a homosexual couple? All of those questions are the first layer of point of contention. And I think this is the layer we are very familiar with. Yeah, so if you can switch to, now we're moving to the third slide. So this is the first, second, and okay, so now here I am with the questions that I want to discuss. When we discuss, go back one, please. Yeah. So when we discuss surrogacy, so beyond the normal questions that we discuss all the time, we also have the questions of the agreement that are usually not very much talked about, but are very important. If you want to enter into a surrogacy agreement, you don't just get the baby out of the blue. You have to do all kinds of things to get the baby. So, for example, we have to decide medical questions. So how many rounds of surrogacy in IVF will the surrogate go through? How many embryos is she willing to carry? What happens if she has too many embryos? Can she abort? Does she have to abort under certain circumstances? Some agreements in some countries have to discuss those questions. Other agreements don't have to discuss it, but I think it's a good idea that they do. You also have questions of insurance. So medical insurance, personal injury insurance for the surrogate. You have questions of privacy. Sometimes she has to disclose information. She gets some kind of lifestyle interventions. So can she smoke or not? Can she, do horseback riding or all kinds of other activities? There are also possibly questions of labor law, and I put this with question mark because under some jurisdictions you can't discuss this under labor law because it's kind of too private. Under other jurisdictions, this could be something of labor law as well. So what I'm saying here is that the surrogacy agreement is not just about the surrogacy. It is a very broad agreement, and the regulation of this agreement has to discuss all of those questions. So we can regulate this agreement as a whole through contracts or through insurance or through privacy or through status. So the first question is, what kind of agreement do we have here? And then I move to the next slide, please. And the next slide should be, first of all, do we have, Francisco, next slide, please. Okay, yeah, thank you. So the first question is, do we want one rule or many rules? Because we have many different questions here. And obviously the raison d'etre of the surrogacy agreement is having the child, right? So that is one focal point for the agreement. And it is true that we have many other questions around it. So we could theoretically have one choice of law rule for the parenthood, one choice of law for the insurance, one choice of law rule for the contract, etc. But if we do this, we have to remember who the parties are. It's not like a multinational business corporations that can manage this kind of litigation. It is usually a woman that doesn't have a lot of money, because usually if she wants to do surrogacy, then there's a money factor involved in many jurisdictions. And there's a couple who is just, the regular people from the street who want to have a baby and they don't have one, right? So for them, this very complex litigation with many different questions would really make this an inviable process, right? So they will never have the litigation. If we want to give them access to justice, then this is not a possibility. And we also can mention the fact that if the litigation is very complex, you might have contradicting answers, right? You might have in the contract, under the contractual rule, the contract is valid, but under the status, it is not valid. So you get different answers and it does not work together. So I move to the next slide, please. So I propose having one rule for everything. And then the question is, what would be the rule? What kind of rule? So it looks like a contract. And so maybe having the choice of law rule for contracts is a good idea. And it would be a good idea, not just because it looks like a contract, but also because contracts promote autonomy and flexibility. And those are things we want to have, right? We want the people to be able to express their wishes and to reach their goals. Also, so contracts might be the best way not only to for them to express their wishes, but also to get what they want. So contracts might be a good idea. But I move to the next slide, and here I propose that the contract, it looks like a contract, it is a contract, but the content, the raison d'etre of the contract is not contractual, right? So the reason we do the whole thing is in order to create a baby, and more importantly, to transfer the parenthood from the woman who gives birth to the baby to another person or other persons. So the whole thing revolves around personal status. Even though it looks like a contract, it really is a matter of personal status. Moreover, if it is about parenthood, we cannot use contracts, because while there is a lot of growing flexibility in matters of personal status, we see, for example, in Rome 3, the choice of law for divorce could be one. Please go back. Yeah, thank you. So in round 3, we see that there's one choice of law rule that has many options, right? So we see some flexibility created in family matters, but still, if there is one family matter that is still a matter of status, that is parenthood. We see countries are still trying to be very strict about it. And also the cost of a limping status for a child is much greater than for a couple of adults who made an informed choice. So for the child, you cannot treat parenthood like you treat marriage, for example. So not only is this a matter of status by nature, it's also a matter of status by necessity or by what we want for it to do. So the type of rule I propose should be choice of law rule 1 rule. That's the first point. Second, it should be a choice of law rule that is in the status format. So not like contract, but like family status. Now I move to the next slide, please. And now the next question, okay, so we have the rule of status, but then the rules of status may have different connecting factors. So first of all, let's discuss who's connecting factor. So who do we want to be connected to? And I know this is very technical, but I'm breaking the rule bit by bit, okay? So once we have the structure of the rule, I want to know whom do I connect the rule, okay? So the first option would be to create a cumulative personal law, meaning that we have to add everybody's laws together. Once I said it, you already hear that it is impossible because of the second point, practical considerations. This would be impossible. It would be very difficult for litigation. It also is likely to not allow these processes to happen in reality because it is so, I mean, there's always one law that would make things wrong. So you really can't do it. But also, my first point is that not all laws in a surrogacy agreement are equally relevant, right? So you would say the law of the surrogate is very relevant, the law of the intending parents is very relevant, but for example, the law of the doctor is for sure not relevant. Maybe the law of the husband of the surrogate is not equally relevant. So we know that we shouldn't choose everything, and we don't have to choose everything because it's just not everything is equal. So now let's start to consider the options. The first option would be, and the most natural would be the personal law of the child. The problem is the child does not have a personal law before we know something about them. So either habitual residence, the child has to live somewhere to have habitual residence, or we want to say the habitual residence of the parents, but then we don't know who the parents are, the same for nationality. So the child's personal law is basically a dead end. So even though this would have been the best, it doesn't work. We have to move to another option, which is the next slide, yes. So we can go to the surrogate's personal law, and we can say, yes, if we discuss adults, she's the main adult, she's the one who's going through the process, she's the one who has to give up the parenthood. But we discuss here termination of parenthood, and she's the one who does not wish to become a parent. So her law is relevant to cutting the ties of parenthood, but not to the creation of new parenthood, right? Because she wants to get away from it. So her law only has to make a decision in one point of the cutting ties, but then everything else will happen in a different law. So it doesn't make sense that this law would govern also what happens after, because it's more limited in scope. Probably also, this is the least protective law. So usually when you have cross-border surrogacy, people move from countries who have very restrictive law, which are also protective, to less restrictive laws, which are less protective. So if you consider the law of California, for example, which is the classical example for surrogacy, the surrogate gets almost no protection there. And if we want to say that the one law of the one personal law governs everything, including insurance and payment and privacy, etc., this law would probably be actually not the worst law for the surrogate, not the best for her. So even if we want to protect her, her law would not be the right law to use. And so another option, and that's the option I like, would be the intended parents' personal law. And I have a whole discussion about what do you do if they have two different laws between them, or each one of them, or whatever. We can discuss this later, but the intended parents. So first of all, this is likely the most conservative law. So it is best protecting of the rights of everybody because it's the most strict law. So if this law has any objections, for example, if this law sets the bar for payment, it is usually higher than the bar for payment in the law of the surrogate, so it's more protective. There might be some contradiction with the intervention of private life in Section 8, and also with the right to grow under the parents, but then we don't have any law that does not contradict this, so it's even if it is problematic, it is not more problematic than the others. And also, and this is my important point here, this is the law that will be most relevant to the reality of this relationship. So as I said before, the law of the surrogate only is relevant once you sever the ties. But after you sever the ties, it is irrelevant anymore. Whereas the law of the intended parents will be the law that would govern everything afterwards, because the intended parents will want to be parents under their law. So this law will have to manage the consequences of these people saying that they are the parents. So it is best that this law would actually think they are the parents. And so A, you get stability and you don't get limping statuses, and B, you get the relevant law to the relevant question. Okay, so now I move to the next slide. We're almost done, so deep breath. So now we have the type of law, the type of rule. So it's one rule and it's personal status, and the connecting factor should connect to the intended parents. And now the question is which kind of connecting factor. So obviously we would think of habitual residence. It is very common. It is what you see in the Hague Conventions recently. It is not just recently, for many years. It is what you see in the EU regulation. And it's becoming also more prevalent in different national laws around the world. And also it has the advantage of reflecting real life. So it is the reality of life, where I actually live and not where I have formal ties that might be irrelevant to me. But the problem with this is it is not stable enough. So the other option is domicile or nationality. And domicile or nationality prevent limping status to the best. Why? Because what the parents need is not just to be recognized as parents. So we have in Minnesota and Lebasset, they said, okay, but they can raise them, they can do all kinds of things. But if you want to have full parenthood, which includes, for example, a passport so that you can bring the child home, which includes the child's right for civil life within the country. So civil participation, political participation, full protection of the law. The best way to get the full protection of the law is domicile and nationality, even if you get the nationality of a country where it is not your habitual residence, because your habitual residence will usually respect your nationality, whereas your nationality might not respect your habitual residence and give a passport, for example, based on that. So I'll give an example just to make this clear. If my nationality is English, but I have habitual residence in France, once England will say that this child is mine, France is likely to respect this and allow the child to live with me and everything else. But if France says that the child is mine, and I have to bring this document to England and tell them, okay, France said this is my child, so please give me an English passport for this child because France said it is my child, England is likely not to do this, right? Because nationality has some benefits that will only follow nationality. So if you go with nationality, it is the most protective law for the for the child, yeah? And it is the best way to prevent limping statuses, which is, to me, the worst problem of surrogacy. So I think this is the right connecting factor. And I now move to the next slide. So basically what I'm saying is we have to apply the law of the intended parents, even though I grant you that it might be the most restricting law. Why is that? Because it's the safest. So of course, if I want to do surrogacy and my national law does not allow it, then I don't get surrogacy. But if I still do surrogacy despite my national law not allowing it, I create a child in a precarious situation because that child does not have nationality. It does not have, for sure, the status of my child. So if we center around the best interest of children, and here we have a conflict. It's for sure you can't keep everybody happy. But if we concentrate around the best interest of children, then we have to say that children come first, even if the parents do not get the surrogacy they want, which is a problem. And I grant you it is a problem. But I prefer the children. They have no choice over the matter. They are brought into a situation that is risky, and we should protect them. So that is my rule. Now, final remarks. So first off, what do I do with ex post realities? That's a big question. I wrote a paper about this where I have this whole proposal of how do we limit the possibility of such things happening illegal, so procedures happening despite the national law saying no, and then what do you do with it? So I have a proposal, how do you limit those procedures so they don't happen? And if they do happen, then maybe, I don't know, but there was an Italian case where the Italian government or the Italian court said, sorry, but no, yeah? It is a very difficult outcome, but it is a good chilling effect for everybody else that comes after. So this, I'm not sure, it's difficult to say that this is what we want to do and people should pay the cost, but it is a possibility. There are no good options here, because if you allow ex post realities, then you just don't have an ex ante rule, right? That's the first point. Second point is countries that do not use choice of law rules, but rather jurisdiction can do the same thing. they can give the sole jurisdiction to the country of nationality or domicile, and then you get the same thing. They apply Lex Fori like in England, and they get the same outcome. And the third point is, as people in this room probably know, there's a proposal of the EU trying to regulate the matter of parenthood. And Ilaria is heading a group writing a report for the EUI. I'm a part of this group, writing a report explaining what the ELI proposes to think about this regulation. And I have two things to say about the regulation. First of all, I think the regulation is too far and too wide and too allowing, and it will create problems with countries that do not allow these mechanisms or are not that open. But the second point is that my proposal works beyond the EU. So I come from a country that is not a member state. And so I have to think about countries that are not within the EU. And the EU regulation is based on mutual trust and mutual understanding that you cannot expect from other countries in the world. So what I'm saying is we can think a little bit broader, we can be a bit more limiting, but we can get an outcome that is safe and sure, not just within the union, but everywhere else, which I think is probably the best outcome for children. And the last slide is thank you. So thank you very much.
Thank you. Thanks to you, Sharon, for the clarity of your proposals, which are always to the point. And as regards I think there will be occasion to talk more about the ex post realities, because there are some ex post realities who are always dealt with as ex post. But I think there will be a little change in the program, because I see Cristina González Bailfus of the University of Barcelona, who will talk about the new EU initiatives in the field of adult protection. I beg your pardon, Abigail Quezada Paez, and maybe you will just intervene after Cristina. Okay? Okay. Cristina, the floor is yours. Yes.
Okay. Yes, thank you very much for having me here, and also for allowing me to present a paper on vulnerable adults in a seminar called About the New Family, because as I will immediately show, this is probably not a family law topic, or at least the European Union does not consider it to be a family law topic. I will try to share my slides. I hope that I will manage. Wait 1 minute, PowerPoint. I think I should be able to. Okay, yeah, it seems to be working. I don't know whether I can make it bigger, or is it okay for you? You are seeing it okay? Is it working?
We are seeing it big. You're okay. Probably not seeing it big, but we do.
Okay, then that's very good. That's very good, because I'm less familiar with sharing slides with Teams. We switched to Zoom a long time ago. Good. Then I am going to present, my paper is not going to be as creative as Sharon's, because I'm going to present the two European Union proposals. The starting point is that, of course, in the area of private international law or cooperation in civil matters, there's a shared competence between the European Union and the member states. And this whole field about adults and disability is still today national private international law. But there are two proposals on the negotiation table now that were published in May 2023, which are one proposal is a decision for authorizing member states to become party to the 2000 Hague Adult Convention, and another one is a proposal for a regulation to supplement the convention's rules. Let me now briefly comment on the Commission's approach and the legal basis. I think what is first very important and very relevant is that the Commission has chosen reverse subsidiarity as its main approach when dealing with this field. So the idea is that they will oblige member states to ratify the Hague Convention and that they will supplement the convention's rules, but respect the convention. And as we will see, the regulation is actually referring to the convention all the time. Now, this is not obvious. This is deference to an international convention, that has so far not been that successful. I mean, besides some member states, not all, but besides some member states, the only other member states, the only other contracting states are Monaco, Switzerland, and for the UK, Scotland only. So it's not a very successful convention, but in spite of it, the Commission's approach has been to respect the convention. So that's already for me a question mark, because it might be that the convention is not as good as we would think. And the other thing, and that's why I was joking that this is probably not a right topic for a family law seminar, is that the European Union decided that this is not family law. And of course, this has implications essentially for the legal basis and for the procedure that needs to be followed. We know that in the area of family law, we need to reach unanimity in the Council, and here we are applying the normal co-decision procedure. It has been contentious whether this is a family law topic or not. I think that in Spanish private law, and I think that it is in the private law of other countries as well, there's a distinction between family law and the law of persons. And if you think that this is a distinction that is also applicable at EU level, you would say yes, because there are adults that do not have a family. And if they are disabled, they would also need to have some issues. But this is not a distinction. And so far, that is accepted everywhere. And so far, I don't think that the Court of Justice has ever said anything about this. Well, and then I will, because we have a very limited amount of time available, I will now actually go to see what the Commission is adding in its proposal for regulation as compared to the Convention. Now, the regulation has rules on jurisdiction, but essentially the main idea behind those rules on jurisdiction is that the regulation is referring to the Hague Convention jurisdiction rules. The Hague Convention is essentially giving jurisdiction to the state of the habitual residence of the adult. And this is respected by the regulation. What is the novelty here? The novelty is that we find a new rule on prorogation of jurisdiction. And this is interesting because this is a new rule that is meant to allow the adult, when he or she is still in a position to protect his or her interest, to select the court that has competence. The idea to have prorogation in adult protection is somehow parallel to the idea of allowing prorogation in child protection matters and in parental responsibility. And the rule that we find in the proposal for regulation is close in certain aspects to the rule that we can find in Regulation Brussels II-ter. However, the problem is that the person that made the choice, and this is a difference, I think, the person that made the choice is actually not able to control the situation anymore when the choice becomes relevant. This is different because in parental responsibility, the persons making the choice are typically the parental responsibility holders, and they continue to have be there and active and able to take decisions at the moment when parental responsibility becomes relevant, at least in most cases. We find that one of the requirements that is new here is that the choice of the prorogation only remains valid if the authorities of the state of habitual residence have not exercised their jurisdiction. So it's somehow subsidiary. It's not going to be prominent if the disabled person has some protection needs and the authorities in the state of habitual residence became active quickly. And then on the other hand, what is common is that it is a choice of a prorogation that is non-exclusive, and also that it is not binding on the courts in the sense that the chosen court can decide whether to take or not to take the case on the basis of the interests of the adult. Now, this concept of the interests of the adult is, of course, much less developed than the best interests of children, and we would need to think more about what are the best interests of the adult. What is the interest of the adult? Is the interest of the adult more to respect what the adult wanted, or is the interest of the adult basically to be assessed more on objective grounds? So I do think that there will be some issues here because sometimes we copy from one regulation to the other, but it doesn't really work. I'm not sure that here it is working as well as one would think of. Applicable law, because I won't have time to go more into many details, but applicable law, theoretically, when we are looking at it, it seems as if there had been no changes because we only find one provision referring to the law that is to the Hague Convention. But here, there is a certain parallelism with what happens in child protection or parental responsibility. The rules in the Hague Convention are tied to jurisdiction. There is a parallelism between jurisdiction and the applicable law. It's based on the idea of what the Germans call the Gleichlauf. Now here we are introducing the possibility of selecting the court. And that immediately has the effect that indirectly we are allowing the choice of law, because by selecting the court, the adult is going to be able to select the law, unless we understand that the rules that establish this parallelism need to be changed. The same problem appears in the Hague 96 Convention, and so far, to my knowledge, courts have always understood that in spite of there being a different jurisdiction rule under Brussels II-ter, we needed to apply the law of the competent court. Other things that one might want to highlight in the field of, in connection to this regulation is in the area of recognition and enforcement. Now, in the area of recognition of enforcement, what we find in the proposal is actually rules that we already know. The new rules that are in this proposal are aligned to the EU rules in the area of recognition and enforcement. So the idea is we get rid of exequatur, we go directly into enforcement. There is no control of jurisdiction anymore, and this is particularly relevant. We do not check jurisdiction, the jurisdiction of the state of origin, because this is the whole system of EU law works like that. There are also rules on the acceptance of public documents that are very close to the rules that we know from other instruments. Of course, these rules on the acceptance of the public documents, they refer to the evidentiary effects of the public documents, not to the content of the public document. Now, of course, if we think that the main idea behind this system of reverse subsidiarity was to respect the Hague Convention, we will have some difficulties because there will be a dual regime. And this is very important in connection to the control of jurisdiction of the state of origin. Now, if the adult chose, let's say I will give an example. The adult who is habitually resident in France chooses the jurisdiction of Spain, of the Spanish courts. Now, this choice of jurisdiction is not going to be problematic if the decision taken by Spanish authorities goes to France. They will have to recognize under the EU rules and will not be able to check jurisdiction. But if the adult moves to Switzerland, there is then the rules of the convention apply, and then they will check jurisdiction. And since this prorogation possibility does not exist under the convention, the Spanish decision will not be recognized in Switzerland. So I think that it is not actually going to work very well in all cases because it creates a duality of regimes. What is, on the contrary, going to work? Oh, I don't see why it doesn't seem to have more slides. Oh, yes, excuse me. What is, on the contrary, probably going to be very interesting is that we have here a European Certificate of Powers of Representation that is introduced in this proposal. It's modeled on the European Certificate of Succession. That's the idea. And we have we have quite detailed rules that take the certificate that already exists in the convention to another level. I think that this European Certificate of Powers of Representation has the potential to be a very practical tool in order to give evidence abroad as to the existence and scope of powers of representation. I mean, powers of representation are one of the areas where the European rules will make a difference, I think. Because the convention was drafted in the year 2000, and this idea about self-determination of adults was not so prevalent in 2000 as it is today. And today, very many legal systems have introduced powers of representation or developed powers of representation, and to have a tool to prove that you are holding powers of representation might become very interesting. Another thing that has also the potential to be very important is that the European regulation requires member state to establish a register for protection measures. I find this very interesting because when analyzing the parenthood proposal, the Commission always said that we could not expect it to require member states to establish a register as to the origins of the child. Well, here they are actually requiring member states that do not have a register to create the register. And these registers will be very useful in order to find out whether these powers of representation exist or not, whether measures have been taken or not. And the idea is that the national registers will be interconnected. Now, of course, the next thing that I wanted to comment on, and I will finish with that, is what is the future for these proposals, because we are still only at the EU, at the proposal level. For the moment, what I know is that they are doing the first technical examination of the regulation, but that the negotiations will not start under this commission. So we should not expect anything to happen until when the new commission will be starting its activities. And in the meantime, there is a very difficult issue that has arisen, namely, there is a common position by the UNCRPD representative, a new position paper, and they are questioning again, because this is not the first time that they are doing it, that the Hague Convention is compatible with the UNCRPD. Now, the only thing that I have that I can tell you about this, because I have not made up my mind yet, I have to really go deeper into this, is that the orthodox position in private international law literature is always to say that there is no contradiction, that the Hague Convention is perfectly compatible with the UNCRPD. However, it is true that the Hague Convention was conceived before the UNCRPD, and people that are coming from more substantive law and human rights law are questioning this compatibility, and I think that this deserves to be investigated a bit further. At first sight, I am a bit worried that they might be defending a position that is that comes a bit close to the position some people have taken in connection to child marriage. So you know that there are some people that have gone so far as to say that if you are against child marriage, you cannot recognize any child marriages contracted abroad. Now, these people, the UNCRPD position seems to be similar in the sense that everything that is not fully respectful of the rights of the adult under the UNCRPD cannot be recognized. I think that a very extreme position actually goes against the spirit of private international law of trying to build bridges. But as I said, I have not made up my mind yet. I have to go a bit deeper into this. I'm going to do this in the near future. And I don't know whether I will agree in the end with the orthodox position, saying that there is full compatibility with the Hague Convention, or I will question this compatibility. In any case, for Parliament, it is likely to become very important. This is one of the things that Parliament might be very sensitive to. And then another difficulty in connection to this package of these two proposals that have been made by the Commission is, of course, the matter of costs. Creating a register and requiring also very intense cooperation in the area of adult protection is going to have cost implications for states. And I am not sure whether states will be very keen on having more burdens. We will see. And that's everything. Thank you very much for your attention. I have to
Thank you.
stop
Thanks to you,
sharing.
Christina. Thanks to you. And now, without further ado, I would give the floor to Abigail Quezada Paez, who is going to take up a very interesting topic, sometimes neglected, that of reconstituted families. Abigail, the floor is yours.
Are you still seeing my screen? No.
Yes, please.
I don't know how to
Well,
stop sharing.
no.
Anyway, I don't have a problem with that because I haven't made a presentation. So Christina, I don't mind if you go to your presentation.
No, but I think it's very unpolite, but I don't know how to.
Just close, maybe just close your document, Christina. I think, Abigail, you may start while we try to solve the issue.
Yeah, thank you to everyone and to the organization. And I have to shorten my intervention because I have class afterwards. So it's going to be a bit shorter than as I would like to. Well, I'm going to talk about reconstituted families, also known as blended or step families, are family units formed by couple who have experienced previous separation or divorces and have decided to merge the life with their children from prior relationship. In this family structure, at least one spouse brings children from a previous relationship, and together they form a new family with the children of their current partner. This involves integrating different family systems and creating new dynamic and relationship. These families can take various forms and sizes depending on the number of children from previous relationship and whether both spouses contribute children to the new family unit. This process of union not only involves a recognition of roles and responsibilities, but also emotional and psychological adjustment for both adults and involved children. It is crucial to recognize that each step family is unique with its own particularities and challenges. In light of these circumstances, we are concerned about the legal framework and recognition of these families, but above all, the protection of minors growing within them. Doubt arises about who should exercise parental responsibility. Our intention is, well, I'm going to focus more whether in the Spanish legislation is up to the challenge posed by these families and whether it's sufficiently protects this the member. To this end, we must address them first and foremost, considering the minor children from a previous relationship. We listed first as their interests deserve superior protection compared to the other family members. The parent with whom the child lives, who has chosen to rebuild his life with another person, that other person who become the spouse or partner of the parent, who we will call the social parent, and last but not least, the other parent with whom the child does not live after the separation or breakup. Step families face a series of unique challenges arising from the combination of members from previous relationships. This challenge can influence family dynamics and require attention and effort from all involved. Some of most common challenges faced by step families include adaptation of children, management of a relation with ex-partner, establishment of new roles and responsibilities, handling different experience and tradition, balancing loyalty and attachment, economic and financial adjustment, and establish open communication and trust. In some legal systems, such as French, Dutch, or English law, the concept of parental authority allows other than the parent to exercise parental responsibilities. This makes it possible to impose on the spouse of the parent a duty to contribute to the support of the non-common child during cohabitation. For example, in Dutch law, even if the second spouse have no blood relationship with the children of their partner, they have an obligation to support them. It is even possible for the parent and the partner to request joint exercise of authority over the minor from the Dutch court. In Germany, excuse me, legal recognition of what is termed social parenthood began in 2001 with the introduction of limited parental responsibility for the spouse of the parents. According to the BGB, the spouse of a parent with exclusive parental responsibility has the authority, in agreement with the parent who has parental responsibility, to make joint decision on the child's everyday matter. However, this provision is deemed insufficient and it depends on the exclusive parental responsibility of the spouse, which occurs only rarely since most couples share parental responsibility after divorce. Currently, in Germany, as in other legal systems, adoption would be the only way for the spouse or stable partner of the parent to acquire the full parental responsibility for the child. In the United Kingdom, since 2005, the spouse or stable partner of the parent can apply for parental responsibility for the partner's minor children under the Article 4A introduced in the UK Children Act of 1989. In the United States, where an estimated 1 in 3 Americans is somehow a member of a step family, there has been an evolution from the traditional consideration that care, custody, and control of a child rests with heterosexual biological parents or adoptive parents to allowing the spouse or stable partner of the parents to assume custody of minor by court order, even against the objection of biological parents, recognizing them as de facto parent. Despite the significant spread of step family occupying areas that should be addressed by the Spanish legislature, there is no reference, at least in the Spanish Civil Code. However, this type of family undoubtedly needs an identifier that provides its member with security, especially in relationship between the spouse or partner of the parent and the later children. Although the spouse or stable partner of the parents exercise de facto parents' function, it still seems to be considered in a secondary position, without finding its place in the legal sphere. Considering that social changes without corresponding rules modification lead to uncontrolled situation, it is now necessary to evaluate this relationship to attribute legal status to the parent's partner that is playing the role played in the family. The link between the social father or de facto parent and the child are not sufficiently protected by Spanish family law. It might need a reform. In the regard, it might be advisable to introduce a provision allowing the spouse or stable partner of the parent to obtain some form of parental responsibility, as already occurs in some countries like in New Zealand and Australia. Until now, It seems that the only faculties in our legal system derives from the spouse faculties to limited to issues related to the child's daily life that do not require the agreement of both parents if they are separated. At least this has been expressly provided for in the compilation of civil law of Aragon and the Catalan Civil Code. It became necessary to speak in these step families of what we could call a parental relationship, where responsibilities for the minor living in the new family unit is assumed by both parents and the partners. This will mean that a person with no relationship to the child, that is to say, no blood relationship, could participate in the daily maintenance and education. At this point, we might ask about the current legal situation in Spanish common law. We are concerned about not knowing the role played by the parent partners in the new family. They do not hold parental authority. It is reserved for the father and the mother. Still, it might be advisable for them to have at least its exercise of some of its function. Currently, in the Spanish civil law, the relationship between the child and the parent's partner does not generate legal obligation between them. It is simplified, not contemplated. The only possible way for the reconstituted family to acquire legal status is through adoption. However, above all, the best interest of the child must be considered because adoption, at least in our law, would terminate all legal bonds, including family relationship with the other parents and the family. However, I will mention that in 2015, the Article 178 of our Civil Code, it was reformed, and a new section states that when the best interest of the minor so advised due to the family situation, age, or any significant circumstances evaluated by a public entity, the maintenance of some form of relationship of contact through visit or communication between the minor member of the origin family deemed relevant, and the adopted family may be agreed upon. Special emphasis is placed on fostering the relationship between biological siblings when possible. For this, the judge must agree to it in the adoption resolution upon the proposal of the public entity. Excuse me. After a positive assessment of the minor best interest by professional from that entity, and with the consent of the adoptive family and the mature minor, and in any case, if they are over 12 years old. This is intended to seek consensual, familiar, and permanent alternative that provide family stability to some minors, especially older ones whose adoption presents more difficulties. With open adoption, the institution of adoption is made more flexible, allowing the family of origin to be better accept the loss, and the child to benefit from the stable life provided by the adoptive family while maintaining ties with the family they come from, especially with their siblings. Alongside the possibility of adoption by the new spouse of the parents, fostering could attempt, but not a situation of abandonment, only with the aim of providing a legal status to the facto father or mother. It would give them a title that legalized them to make decisions without eliminating the minor relationship with a biological father or mother, allowing the minor to stay under custody of the facto father or mother, when convenient for the interest, when agreed upon the natural parents will be amounted to legitimate delegation agreement, not of authority, but of custody. The reality, in most cases, neither the adoption of the minor nor the attribution of parental authority take place, but the parents partnered de facto exercise the guardianship of the minor, while attributing custody to the minor to the stepfather or stepmother alongside the parent's spouse would not change the nature of the relationship between the other biological parents and the child. This situation can be uncomfortable for the other parents. They may feel that the role will be marginalized and the balance of power will be unequal between them and the other parent and their new spouse, forming a new family. In these circumstances, if there is no agreement, it will be brought to court and considering the minor's best interest. The judge will evaluate both the nature of the minor's relationship with the biological parents and the relationship with the spouse of the other parents. In the light of all of above, we conclude that there are not be such a disconnect between legal norms and the social reality we find ourselves in regarding this matter. The question boils down to whether in step families, some parental responsibilities should be recognized for the spouse or partners of the partner concerning the minor living in the family unit. In any case, at least for now, the proposal to include the partner of parents in reconstituted families in Spanish common law will align with the Catalan legislature approach of allowing them to at least participate in decision making related to daily life. Still, with the notions that the criterion of the parental authority holder should not always prevail. This is because it will cast doubt on whether the legislator is safeguarding the best interest of the minor. The dilemma, therefore, lies on how far we want to go. If we limit the participation of the spouse or stable partner of the parents in decision making, or if we also want to attribute them protective function, close or coincident, even those that make up the exercise of parental authority. Let's say this is a really hot topic and it's much depending on the specific case. But from my point of view, I have a more conservative view, and I will follow the line that to at least just that the stepfather only participate in the decision making related to daily life. Okay, and that's all. Thank you very much, and I have to leave. I'm really sorry I cannot stay. Thank you very much.
Thank you very much. Thank you, Abigail. And now we are a bit out of time, but we have now the last speaker, who is Jens Martin Serpe, who is professor at the Aalborg University in Norway, and he's also the president of the Nordic Center for Comparative and International Family Law, who is going to speak us about a comparative view on the legal status of de facto relationships. So please, Jens.
Yes, thank you very much. I'm starting the PowerPoint, and I hope that this will work. If not, we have Francisco as the backup, so that should hopefully do.
Yes. Okay.
Right, and now is it being shared?
Yes.
All right. So oddly enough, it doesn't show on my screen. So I don't usually use Teams, which is making this a bit difficult. So I can't really see what I'm doing. So
Yeah, you have.
That looks better. There we are. Right. Okay. Thank you very much, everyone. And apologies for keeping you from your well-deserved rest. I understand this has been running over. Apologies also for coming up late because I was actually teaching in Hong Kong online as it was. So I'll try to keep it brief and at the same time not to speak too fast. So I'm presenting a research project that is very much ongoing, although it shouldn't be. It was supposed to be completed a while ago, but you know how these things go. So the background is that together with my colleague Andy from the University of Durham in England, we started a project on the legal status of de facto relationships. And in fact, that is a topic that has been with me for quite some time because bizarrely, my first major independent publication as an academic was on this. That is Die Rechtsstellung nichtseheliche Lebensgemeinschaften. Unfortunately, most of the pieces in there are in German, but the good news is most of them are out of date anyway. So you can actually hope that the English edition will be a bit more interesting. It's also more wide-reaching. I was also part of the Law Commission's Advisory Council when it came to their proposals on cohabitation, which never went anywhere in 2007. Because the governments since then have shown no interest. But interestingly, I've been approached by the Labour shadow government to discuss the prospects of doing this if and when Labour should come into power. So maybe these will be revived in 2024. Now, the reason why Andy and I undertook this study on de facto relationships is because we had this one here previously, and that is basically the corollary. It is for registered partnerships. So we asked, what are the alternative recognition of families in a formalized way? And that was a study of 16 jurisdictions only. I will not go into the details because we're running very late as well. The book's been out there for quite some time. Now, what are we doing now? Well, we got more ambitious. It's a comparative study of 38 jurisdictions from 6 continents. We started this in the pandemic in 2020. And hopefully, this will be forthcoming in 2024. We have all the 38 national reports, so the ones who are dragging their feet are basically Andy and me now. So it's quite far-reaching. I will not go into this, and of course, some of the authors are in the audience today. Thank you again for your contributions. So these are the European and the Asian ones. Then we have Oceania, North America, Africa, and South America as well. So lots of jurisdictions covered. And in order to give you the overall picture, that's what it looks like globally. So this is probably the most ambitious project in terms of region that I have undertaken in my work so far. So you may note that my terminology has changed. Our terminology has changed. We moved from cohabitation to de facto relationships, thanks to learning from our Antipodean friends. Because essentially in the English language, married couples cohabit. So cohabitation as such is probably not such a good term to delineate this. And also we felt that the term de facto is more appropriate because that is what we're exactly looking at, namely where people live together without being married, without taking any formalities, and we are extending legal consequences to them during the relationship, upon breakup and upon death, just because of a set of facts. So we faced quite a few challenges, not only the very different social legal cultures, which made the drafting of the questionnaire a joy. We were, of course, looking at very different levels of acceptance of relationships outside of marriage, especially with regard to same-sex relationships. In many jurisdictions, there were difficulties drawing boundaries between formal and informal relationships. We decided to limit ourselves to conjugal relationships, so perhaps the follow-up project is for non-conjugal ones. That could be interesting. But the key issue, and I'm going to come back to that a couple of times, is the interconnectivity of the qualifying criteria for recognition and what comes from them, so the remedies. On a practical level, suffice it to say that with such a broad range of countries, there were very different approaches to legal scholarship. So we drafted a questionnaire. This is the basic structure that we had. I'm not going to show you the questionnaire in detail, don't worry. So obviously some introductory parts, then qualifying criteria, what happens during, what happens after, the relationship in case of separation or death. And then we looked at children as well, and we had current problems and debates on board. Because we are very short on time, and I was only given 20 minutes anyway, straight to the overview. And I've stolen this one from my delightful colleague, Joe Miles. What we can say is that ultimately, whatever a jurisdiction did with regard to the recognition of de facto relationships was drawn by certain policy considerations. And as you can see here, they're drawing in different directions. So you have the battle between autonomy and protection of the vulnerable partner on the one hand, and then equality of de facto partners with marriage and the preservation of the traditional family as a political motive is the other axis. And then you can see where people, where jurisdictions put themselves. So you will see on the left-hand side, at least from my point of view, that's the opt-in possibilities. And of course, that is not what we're talking about. You can see the lovely crooked X's because I allowed one daughter to do one X and one daughter to do the other. I will not let you vote on which X is the nicer one, but that is how it came out. So what the project about is only the default systems, so those that apply without any further action being taken just by virtue of certain facts. So the one part that I'm going to spend a bit more time on today is the qualifying criteria parts, but it's interesting to see as sort of preliminary findings that we found that the narrower the definition of the qualifying criteria, the more specific and indeed far-reaching the remedies were that the jurisdiction offered. That, of course, is logical, because if you very clearly define to which group of people this applies, then you can tailor-make the remedies accordingly. We also found a difference between some common law jurisdictions and civil law countries in particular, because common law countries are generally more familiar with discretionary remedies. They have those for marriage as well in many jurisdictions. And therefore, there's a greater flexibility as regards to the remedies because they can be adapted to the individual case. For example, take into account the level of commitment in the relationship and so on. And therefore, there's also greater discretion and wider qualifying criteria in those jurisdictions because the remedies can be adapted. So once again, and I highlight this here, it's the interconnectivity of qualifying criteria and remedies that we see. And of course, the policy pursued, whether it's assimilation or difference compared to marriage, determines the extent of the remedies. So what were we looking at typically? What we saw in many jurisdictions is the rather absurd comparison with marriage. So living as if husband and wife, and of course it is absurd because the whole point of these rules is that the couple are not husband and wife. So the comparison is a bit nonsensical to begin with. And frankly, husbands and wives live in very different ways. I could not tell you a clear-cut definition of how a husband and a wife lives anyway. So more sensibly, some jurisdictions, the qualifying criteria are detached from the marriage ideal. So for example, a couple living together on a genuine domestic basis in Australia, or living together as a couple in an intimate and committed relationship like in Ireland. Of course, these also reflect basic policies already for these jurisdictions. Of course, gender is a criterion because same-sex couples are excluded in some of the jurisdictions we looked at. Age was a factor, prohibited degrees, very often similar to marriage, and then whether sexual relationship or intimacy was required in some cases. None of that very surprising. Living together was a criterion that was very often mentioned, sharing a household. But more and more jurisdictions are coming and accepting living apart together. So couples who live separately but still consider themselves as a couple. The minimum duration requirements were particularly interesting, and I will not read out the different time frames. So sometimes they're stipulated very clearly. Interestingly, joint children in many jurisdictions can mean that the minimum duration is falling away or that it is shortened. Because obviously it was felt that then this is precisely when the protective scope of the regime is needed. What we did find is that if you have very clearly defined timeframes, we often have evidentiary problems. Did your toothpaste and your underwear move in on the Tuesday, or was it the week after on the Friday? That can be determining in some of the cases if they're close to the borderline. And so there were quite many cases reported on precise definition of these borders. So other jurisdictions, therefore, quite sensibly operate with significant duration, i.e. they leave it to the courts to decide whether the relationship was a qualifying one or not. Others that do have a time limit have so-called hardship clauses, which allow the courts to set aside the time criterion when the facts otherwise indicate a qualifying relationship, and it would be unjust not to recognize it. Particularly interesting, I found in the comparative study the approach to concurrent relationships, because they can lead to disqualification, especially if one partner is married to someone else. And this is interesting because one needs to ask, what is the protective purpose of this scheme, and should that actually be diluted just in case a person is still married to someone else, although the relationship essentially has been dysfunctional for a decade or two? And that, of course, is a policy question that each jurisdiction needs to answer. And others, that is no problem whatsoever. The system applies concurrently, and then we have rules on how the assets are to be divided if both of the partners are entitled. And I will draw your attention to the extremely interesting case of Mead and Paul of 2023 of the New Zealand Supreme Court, where that was a polyamory case. And that was dealt with very sensibly in the way that all the polyamorous relationships were recognized individually rather than the polyamory as a whole. So that was a very interesting way to deal with this under New Zealand law, well worth a read. And there's a good commentary on that in the German FAMAZ as well. Now, contracting in is very typically a criterion, but as I said, this is what we dealt with in the previous book, The Future of Registered Partnerships. So that was not our interest here, but some of the jurisdictions that we looked at, like those listed here, contracting in is possible despite the fact that the system in principle is a de facto based one. And that means that you can avail yourself of the system even if otherwise you have not met all of the relevant criteria just by contracting in. We call these hybrid systems. And that means that you can make sure that these legal rules apply to you, and they also, of course, remove many of the evidentiary problems. In other jurisdictions, we often found that there also was the possibility to register, but that is only for evidence and did not have any legal consequences as such. Since we're talking contracting in, it's worth talking contracting out as well. So in order to safeguard the autonomy of the couples, many jurisdictions allow for an express opt-out of the de facto regime. But we do see very often limits to what can be opted out of. And there are procedural and substantive safeguards that are applying, and they are comparable to those for prenuptial agreements on which there may be another publication that you might have seen before. So I'm not going to go into detail. So we then very briefly, because I know we're running very late, we of course looked at the legal effects upon separation, and that was one of the major parts of the book, and still is, of course. And again, I need to highlight the interconnectivity of qualifying criteria and remedies. I mean, this cannot be stated often enough, because that really determines the outcome. And of course, the policy pursued again determines the extent of the remedies, and you see a huge variation. So relationship property regimes or rule-based sharing is in place in some of the jurisdictions, which are tailored to this specific situation or are similar to those of marriage, depending. Then we have in some of the common law jurisdictions which have equitable and discretionary distribution for married couples, the very same for unmarried couples or couples living in a de facto relationship. And then you have regimes that distinctly go for a different approach as well and have their remedies based on the notion of compensation or damage type claims. Japan could be on the list here as well, actually. It's also interesting to see that we included some of the jurisdictions where no specific de facto regime actually exists, and that in these jurisdictions, generally, the poor judges fall back on the general law to provide some remedies, such as implied contracts, which is particularly popular in the United States as a remedy, unjust enrichment, which is the main tool in Canada, implied company law or partnership law, which is what the Germans tend to do, bizarrely. I mean, if you didn't know, if you move in with someone and you might actually have formed a tacit company, and that is, having a joint life. And if that purpose of your company then doesn't materialize, the assets can be liquidated according to company law. Japan, for example, resorts to tort law or damages, and of course the common law jurisdictions also have trust law to help them out. So Hong Kong and England and Wales, for example, are using this. What we could see from all these remedies is that we think they're generally unsuited to provide fair and just outcomes, because they can only do this to a very limited extent because they're not tailor-made for the situation at hand. Right, so that was a bit faster than I was hoping to go, but of course we're running very late. So we do hope to finish the project reasonably soon. We're working on the comparative overview as we speak. It's quite ambitious, and it's interesting to see how the approaches differ. And the more traditional the society, the more likely it was that they basically trying to convert the de facto relationship into something like marriage, because that's the only tool that is available. In other jurisdictions, living together without being married has long been accepted as a fact of life and is addressed by specific legislation. But it's also interesting to see that in many jurisdictions where it is accepted as a perfectly normal way of living, there are no specific rules in place. And of course, we have the usual debates on whether a de facto regime would infringe the autonomy of the parties or not. I have my very distinct views on that, but I think I'll leave it for now and cede the floor for the discussion that I think is still scheduled, so I won't keep you much longer. Thank you very much.
Well, thank you very much, Jens. And now it's time for a short turn of questions. Do you have any of the assistants have any question? Please raise your hand. No. Well, it's all clear. Well, then, as we are very late, we are going to pass to the final remarks, and the closing remarks will be very short. Thank you to all the speakers. Thank you to all the assistants for assistance, and well, I think we have had important points of view of these matters about children and about new family models. First, we have had the intervention of Virginia Zambrano about the legal systems and the different legal systems and the harmonization of family law in Europe. Afterwards, we have had Roberta Marino with the equality between parents and the surnames of children. Thirdly, we have had Maria Dolores Casas about the guardianship and the minors without parental care. For closing the first section, we have had Giovanna D'Alfonso with the children's access to the web and the digital world. In the second session, we have had Sharon Shachardy talking us about the choice of law in surrogacy agreements or contracts. Afterwards, we have had Cristina González Belfus, who has given us a very interesting speech about the new EU initiatives in the field of adult protection. Thirdly, we have had Abigail Quesada talking us about reconstituted families, and finally we have just had Jens Scherpe talking us about this interesting subject of the comparative view of the legal status of de facto relationship. Well, thank you to all of you again. We have had, as I told you, we have had this event being recorded, so we have given you the recording, and we have now intending also to giving you the abstracts of the interventions. Finally, I'd like to remember you about the event this afternoon at 5:30. Those who has the luck to be at Pisa has the appoint at the Palazzo della Sapienza in Pisa, and the other people who are not so lucky have the link for following it online. I'm now giving you the link for those interested in following this interesting event about new technologies and filiation. And well, finally, again, thank you very much for all, to all of you, for attending, the attendance, for speaking us about so interesting matters to the speakers, and I hope to see you again very soon to you all. Thank you very much, and well, bye.
Thank you. Thank you. Bye bye.
Professor.
Thank you. Thank
Thank
you.
you.
Thank you so much
Thank you.
for all.
Bye bye.
Bye-bye.
Goodbye.
Goodbye. It has been a pleasure. Vamos a ver.